Hey folks, James Abrenio, and I wanted to talk to you about something specific under Virginia criminal law, the concept of a deferred finding. First of all, let's talk about what it is, and then we'll talk about advancements in the law most recently that makes the options a bit more flexible and a bit more forgiving in certain circumstances. So, what is a deferred finding? Under Virginia criminal law, if you're charged with a crime, the court, after a hearing or upon a plea, can find that the facts are sufficient to convict you, but instead of entering that conviction, the court can then defer the case out for usually a year or two and set on various conditions. If you comply with them, upon a return, the case can be dismissed against you, so you're not convicted. So, in many instances, a deferred finding can be a really great thing. So, let's say you have an individual that's charged with a crime, they're dead to rights, guilty. There's no chance of winning at trial. A court can essentially give you an avenue to get a deferred finding and then avoid a conviction. So, this oftentimes previously would come up in, for instance, cases that allowed or charges that allowed for first offender programs. For instance, domestic violence allowed for a deferred finding, trespass allowed for a deferred finding. When marijuana was still being criminally prosecuted, there was a first offender statute there that if you were dead to rights on the circumstances and assuming there wasn't aggravated factors, you could typically get essentially a deferred finding and avoid a conviction. And many times this is a great avenue because, again, it can avoid a conviction. Now, prior to 2001, though, there were issues with deferred findings in that the court, one of the issues was the courts were essentially saying, unless there was a specific statutory authority, the courts did not have what we call inherent authority to defer cases. So let's say you were charged with a crime that didn't allow for a deferred finding. So let's say a simple assault or other statutes, let's say a destruction of property where there was not specific statutory authority. The courts, essentially the appellate courts, were saying to the state courts, the trial courts, you don't have inherent authority to grant deferred findings. So even when the circumstances warranted and it seemed appropriate and the prosecutor would agree, a deferred finding was not an option. Also, prior to 2001, if you took a deferred finding, the result would, assuming you complied, it would get dismissed, but you would not be eligible for what we call an expungement, essentially the ability to get the records of the arrest and police records sealed or destroyed. Now, fortunately, in July of 2021, Democrats took over the houses of government, and we were able to see a lot of criminal justice reform. And the concept of deferred findings was expanded, and the statute of Virginia Code Section 19.2-298.02 was created. And what that essentially said is, and there's different subsections in the statute itself, but I'd highly recommend you take a look at that, Google it, and take a look at it. But essentially, this allowed for an avenue for deferred findings in non-statutory remedy cases. So, for instance, you could get, upon agreement by parties, you could get a deferred finding under an assault, for instance. What it also allowed for in cases where there were already deferred findings and charges where there were already deferred findings, but under the prior deferred findings, you couldn't get expungements. There's now an opportunity, if the circumstances are appropriate, to get a deferred finding under 298.02 that allow for expungements. So a big example where I've been seeing this being used lately are in domestic violence cases. Let's say that there is a domestic violence case where there's not alleged injury. It's a very nominal touching, let's say a push or a smack or something like that. And let's say there's a real risk of the Commonwealth losing at trial. They may now offer a deferred finding under 298.02 with an agreement that if the individual is compliant, that the case will be eligible for expungement. That avenue typically wasn't available before. In some jurisdictions, what we would do in situations like that, something called a general continuance, where it was essentially the case would be continued for a period of time. There would be no agreement that the court was aware of. It would essentially be a private agreement with the prosecutor's office and the defense attorney that if they complied, the case would be essentially dropped. That would happen in certain jurisdictions, but prosecutors are very limited in granting general continuances unless there was something really flawed about a case. Essentially, 298.02, the deferred findings under 298.02 now allow for kind of a more stringent a deferred finding that allows for some teeth that, if not compliant, the defendant will fill if they violate the deferred finding. So in order to get a deferred finding under 298.02, there's a few things that have to be recognized. Number one is the parties all have to agree that it's eligible. You can't get a 298.02 deferral unless essentially the Commonwealth agrees. The other thing is, if you enter a deferred finding under 298.02, the accused, the defendant, has to acknowledge that his rights or her rights to appeal are now waived. So it can't be a situation where they take the deferred finding, they fail to comply, they come back and they just want to restart the clock and then try to start it from day one. If you take a deferred finding under 298.02, you've waived your appeal. And typically what will happen is, if you then violate the terms of that 298.02, you will indeed be convicted of the underlying charge. This video is a bit more technical, and I think that if you're watching this, I think that you should, if you're working with an attorney, or if you're working with me, I urge you to then come back and rewatch this, because I think in order to understand the concepts, you got to be a little more ingrained into the process, because there's various other things that can be happening in your case. I also want to be clear, deferred finding via 298.02 is not going to be the average scenario. It's not like you're going to be charged with a DUI or domestic violence charge and they're just going to outright offer this. This is going to be exception rather than the rule. Have I had this happen in many cases? I have, but I've had a lot of cases. And so it's not the normal outcome. There's usually something flawed about the underlying case that encourages a prosecutor to offer something like this. But it is a concept and a statute that, if you're charged with a crime, you should at least be familiar with, so you can at least talk to your attorney about the possibility, even if it's not a possibility, so you can at least understand that. So hopefully this video was helpful, and hopefully it answered a bunch of questions. Probably raised a bunch of questions as well. So feel free to reach out to us. Phone number is 703-570-4180. Thanks a lot. Wish you guys the best. Thanks. Bye.